Pennsylvania is a hybrid state in the parlance of the literature on the representation of children. Some states in the nation are council states. Lawyers for children play the role of loyal and confidential advocate, traditionally associated with lawyering. Other states are more classic guardian ad litem, best interest states. These lawyers serve as officers of the court, not bound by the child's confidences or expressed wishes. Pennsylvania blends these two by statute and rule. And so we are indeed the hybrid of counsel and best interest guardian ad litem. And one can find guidance on this role in the Juvenile Act. We turn there for much of the direction and content of representation, along with some other key signposts like the American Bar Association Standards of Practice for Lawyers Who Represent Children in Abuse and Neglect Cases. The ABA standards give us these definitions: the child's attorney, bound by confidence and loyalty, advocating for what the child wants. Best interest attorney, best interest guardian ad litem, not bound by the child's preferences, but driven by what the child needs, what's in her, quote, best interests. The guardian ad litem in Pennsylvania has this unique, important role of serving as the voice of the child in court. We're all required by law, Pennsylvania law, to be lawyers, and we bring the full range of our legal skills and training to this table of practice. We engage in motion practice, in investigative and discovery practice. We make argument. We also collaborate. In that way, it's different than some aspects of classic lawyering. We work with the other parties and their lawyers. We try to find the right answer for this child, to bring to the court what the child needs and wants in her life. I like to talk about 4 fundamental rules of child advocacy. The first, know the child. And so the ABA standards guide us. Establishing and maintaining a relationship with the child is the foundation of representation. One might imagine this is different from some forms of lawyering of business clients or even adult clients, where you might know your client, you may or may not like your client, but relationship's a different business. But here in the representation of children, of course, they've been through rough times. Sometimes their very ability to trust has been compromised. The lawyer, the guardian ad litem in their life, we have a kind of a role to restore that ability, that opportunity to trust that's so important in being a child. Know the child. Know everything there is to know about the kid. Get a thickly detailed view of what this child wants and needs, likes and dislikes, her background, education record, behavior, needs, deficits, health issues, dental issues, behavioral health, any counseling history, what she likes in school, where she's been to school, where she wants to go. Continuity of school is very important for kids in the child welfare system because, of course, removal from family often means removal from school. There's very important law speaking to the stability of a child in her or his school of origin. Our third rule of child advocacy, know those who know. In child welfare work, children and youth have a sometimes large array of professionals who've been involved in their case. There's certainly all of the professionals and lay folks who were involved with their life before they came to the system, their teachers, their physicians, their family members, and others whom they trust, others who they've had some connection with, who know them. And then there's all these folks that we introduce them to when they come into the system. There's the foster parent, the foster care worker, perhaps a therapist or a set of therapists, the mobile therapist, wraparound therapist, developmental specialist, the person who's working with them and their parent perhaps. Perhaps there are supervisors to all of those folks. There's the children and youth worker and the lawyer for the Children and Youth Agency. They often have information about the child, what she needs, what she's been through. There's the child's siblings, Siblings are so important in many ways. We'll look to their need to visit with each other, what opportunity we have, how to make visits happen. Siblings are also important in terms of the knowledge they bring about each other. Kids, they tell secrets amongst each other, and so you might have opportunity to talk to a child whom you represent and her siblings together. Sometimes, of course, we represent sibling groups. It's another part of in a sense, the standard of practice in Pennsylvania. The courts often invite a guardian ad litem to represent all of the siblings in a group, unless there's some conflict of interest between them, in which, of course, by law, they get separate representation. The fourth rule of child advocacy: let the court know what it needs to know, what it's important for the court to know. The court has a discrete and specific obligation in these proceedings. As we'll hear at the adjudicatory stage, it's to ask questions about whether the child has an able parent in their life, and then at disposition, what this child needs from their parent and from those others involved with the child. Your job is to help the court get to its decision. It has the most important role of all. The court's responsible for the care and well-being of the child to make decisions and orders. And the court looks to the guardian ad litem for part of the answer. Kids who've been involved in the child welfare system are often victims of abuse or neglect. Sometimes as well they have collateral experiences. They're secondary victims because of something that happened to one of their siblings. All the kids involved with the system need the opportunity to heal. They come to us for that opportunity. They come to us for that healing. Our job is to help that healing go forward with services, with supports, with family permanency, with people in their lives who can help change that sad story.
I've been asked to talk about what it means to be a guardian ad litem in the Commonwealth of Pennsylvania. And the task in Pennsylvania is twofold, which makes it somewhat difficult, because while we are serving as guardians of these children, we also have a responsibility to them as counsel. And sometimes that requires us to not only share with the court what our children want, but also what we view is best for them. And when those two things collide and they're different, it leaves us in a very difficult position. We have to remember that our court is asking from us something that they can't get from the advocacy system as it stands. If we only repeat back to the judge what he's already heard in the room, we're really not providing him with any additional information with which to make a decision. So our courts are asking of us as guardians to give the court more insight and more information than is available in the hearing room. And to do that with integrity and honesty to the court, it requires us to do more work behind the scenes. It doesn't help to just parrot what the caseworker thinks, or even what the child thinks, or even what we might think if there isn't any information to back it up. So we're in a very unique position in that we're the only person in the room that gets to give our opinion without being subject to cross-examination, and we're also not put under oath. So when the court asks us what we think, I would strongly encourage you to know that you have the information to back up that opinion and be coming to that opinion with as much evidence as you can. Additionally, we're given the opportunity to present evidence to make our case. It's not enough to simply go in and say, Johnny, the court wants to know what you want and you want to go home, and Judge, I think that's a good idea or it's not a good idea. You need to find the witnesses who can make the case. You have to remember that you are these children's only voice in the courtroom. And if Johnny wants to go home and there's a way to make that happen as safely as possible, it's your job to make that case. So find your witnesses, prep your witnesses, call them to court, subpoena if necessary, and put on the best case you can. Sometimes when we have to explain to children that they're not going to get what they most want, it's a tough thing, and it can be done artfully and gently, or it can be delivered harshly and sorry, you're not going to get what you want. And I would encourage you, as you go through this line of work, to find that artful middle, which is sharing with these kids what they need to know, making sure they can take ownership of the process, and hopefully, encourage them to use their own voice in the court. Because while you're helpful, and we like to think that we're priceless in the courtroom, the best words come out of the mouths of our children. Because when it all comes down to it, it's about them. And we're best served when it's not happening to them, but it's happening with them, that they're part of this process. So I encourage you to find that artful balance, which will come the longer you do this work.
As the guardian ad litem, you are faced with the responsibility to present the evidence of this case. Not in the primary case, because the solicitor for the Office of Children and Youth will present the underlying evidence to establish the petition for an adjudication of dependency. Your job is to make sure that that evidence is accurate, presented fairly, and protects your client, the child, the vulnerable child. You must have an opportunity to present your evidence. Make sure that it is put on the record, that it is presented to the trial judge in an accurate, clear, and fair fashion. The evidence is only the facts that are prepared and presented to the case. Make sure you have an authentication of the medical records, that you know what the issues are, that if you want the mother to testify or the father to testify, that they are sworn in as witnesses and to present true and accurate testimony. We on the appellate court look at the case. We look at a cold, cold record. The case that is presented to us has no new facts. The trial court makes a ruling on an adjudication of dependency abuse. Once the trial court makes that determination, there is a right of appeal. That's when we get involved. The Superior Court is an error-correcting court. We take a look at the record which has been prepared, and we look at the cold record. If you have not admitted your evidence, they do not come in. If you have not placed your objections on the record, it does not come in. You must give the trial court the opportunity to correct any errors. If you fail to do that and you fail to raise it before the court, typically that issue is waived. So take a look at your responsibilities, and as we go forward, present your facts, do your due diligence, do your homework. It is an awesome responsibility that you are charged with, but it is one that will forever change your life, because the work which you do increases the ability for a child to thrive and makes a long-term permanent plan. So on behalf of the Superior Court, the Appellate Court of Pennsylvania, we thank you in advance for your work. Looking forward to seeing you in court.